I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Today, we're continuing our conversation relating to insider threats. You may have heard prior podcasts where we focus on the start of an investigation, what is an insider threat, and including most recently, what is unique about conducting an insider threat investigation in the United States. And we're continuing that series today with two of my colleagues, Christine Gateau of our Paris office and Thore Feil from our Hamburg office. Christine and Thore, thanks so much for joining the podcast. So explored ideas in prior episodes surrounding what an insider threat is and how it's unique in the cybersecurity world. And one of the aspects that we have started to touch on is that a cybersecurity-oriented investigation, tends to take similar shapes. But what is unique about an insider threat investigation is that it actually looks very different than a cybersecurity investigation. In fact, a traditional cyber investigation is only part of what we do in an insider threat investigation. And it's also important to note that the US approach to insider threat investigations may not work in Europe. In fact, I think as we're going to discuss today, it doesn't. And it may not work in Asia Pac. And in fact, when we start to conduct an insider threat investigation, we need to be sensitive to the jurisdictional differences that appear in all of the places where that insider threat may appear. So that's where I'd love to start our conversation. And Thore, maybe I can start with you, because one of the key components of a successful insider threat investigation is making sure that we have the right stakeholders involved as part of the working group. And I think, as I understand it, it's actually slightly different in the EU, where additional stakeholders need to be involved as part of that investigative team. Maybe you can kind of help us understand from your perspective who needs to be included.
Yeah, sure. Thank you, Scott. Yeah, I think this is an important question. And the short answer is yes, in many cases, there are persons or bodies within the company that need to be informed before conducting certain investigative measures. Besides potential duties to report incidents or internal investigations to the executive or supervisory board, which of course highly depends on the legal structure of the relevant company and its internal statutes, there are in particular two bodies whose involvement should be reviewed before conducting measures such as data reviews, workplace monitoring, or employee interviews. The first one being the Works Council, or also other employee representative bodies, depending on the EU country. While there are differences across the European Union and country-specific analysis is necessary, overall, I believe it is fair to say that the general level of employee participation rights in the EU is significantly higher than in the US. And this is why it can sometimes come as a surprise, especially for US clients, in how many cases the Works Council needs to or should be involved. For example, in Germany, the Works Council does not have a general right to participate in internal investigations, but in many cases, certain co-determination rights apply. So the Works Council needs to be involved if technical equipment or software that processes employee-related data is used, which is usually the case in internal investigations, for sure. The employer must then inform the Works Council comprehensively and in line on the modalities of data collection and processing, and also the questioning of employees in connection with compliance violations or other misconduct in many cases also opens up a right of co-determination in Germany. And even if one comes to the conclusion that there's no legal obligation to involve the Works Council, an alignment can be advisable nevertheless. This is due to the reason that the Works Council, at a certain point of the investigation, usually becomes aware of the conducted measures anyhow. So without any prior information or alignment, this could lead to significant pushback and unwanted escalation and delay. It can also have a negative impact on the overall work atmosphere in the company. So for this reason, and this can be helpful to obtain the employee's cooperation. It is generally best practice to allow and offer the participation of a Works Council member also in employee interviews.
So, Thor, can I just maybe pause there? Because I think that's an important point, and is certainly unique in the way that I think those countries in Europe that have works councils or have a history of using works councils differs than certainly what we have in the United States, where maybe the closest corollary is labor unions, and I think differ from other regions in the world. One of the aspects for an insider threat investigation is that you don't really know kind of where that threat is coming from. And so usually we start our investigations by trying to keep the group of people who were involved as part of the investigation as small and as narrow as possible before trying to, bring in others, because we were trying to eliminate possibilities and trying to make sure that we're not unnecessarily or potentially including somebody within our investigative team who may ultimately be part of the issues that we're investigating. When you're going to a works council, right, and informing them of this investigation and kind of working collaboratively, including through the various tools that you would use, how do you kind of create that balance between trying to keep a small and tight-knit group of investigators versus going out to a larger set where you may spook people, you may end up talking with somebody that you are trying to, in fact, investigate and identify any wrongdoing?
Right. So maybe first of all, in many cases where we contact the Works Council and align with the Works Council on investigative measures, it is usually still possible to keep it confidential. So it is not the case that the information gets spread out in the whole company.
Got it. And Christine, I know works councils are often, heavily used in connection with companies in France. Interested in your perspective on that. If I am a company who's engaged in this type of investigation and I'm informing the works council around the investigation and what types of issues we're trying to investigate, what's your perspective on trying to maintain the overall confidentiality of the investigation itself?
I think that would be the same response and answer as Thor. In some ways, employment law in Germany and in France may be similar. In other, it's different, obviously. But the fact that you may have, under certain circumstances, under French law, you may have to inform the work council because the investigation that you would be conducted would be large, for example, does not mean that the information is going to go beyond the circle of the people who are elected to be part of that work council. So that's the first thing, obviously, to have in mind. Sharing that information with that body does not mean that you're sharing with everyone in the company. But apart, obviously, from what Thore has mentioned, there are also other bodies to be taken into consideration if you're considering the European Union perspective as well. One other big body may be Data Privacy Authority, for example. If the threat has materialized already, if you had already a cyber incident, for example, you may need to report the incident before you actually started or concluded the investigation, because the time frame to report a cyber incident are really, really short. So you may need to do that before actually knowing all the elements of the investigation. In some countries, you may want also to actually involve the prosecution authorities because they may have access to information that you would not have had access as an employer, for example. And it may actually be helpful to your investigation to decide at the outset that the investigation is going to be conducted in a broader way and with more resources, with the help of a criminal prosecutor to some extent. And in other instances, that may not be necessary, or even you might consider it to be counterproductive because it would slow down the process. So depending on the country, depending on how exactly, if the threat is only a threat or if it has already materialized in an event, all those elements need to be taken into consideration to be sure that you have informed all the relevant authority. And obviously, there is one more, because with the GDPR, you also have to warn usually the data protection officer. Again, if there is a threat which is sufficient, or again, if that threat has materialized in an incident, the data protection officer needs to be informed of that event and of the potential processes of the investigation that you are contemplating. So a lot of bodies on the task list that you may have to add in comparison to the United States.
Yeah, really interesting. I think that would be, for our audience who have kind of gone through some of these things, I think maybe areas of opportunity, because typically, in the way that US investigations are run, there will be a moment where law enforcement will certainly be part of the conversation. But typically you'd want to come up with a strategy of developing as many of those facts and kind of coming up with your dossier of what you've learned to help present that to law enforcement. And it sounds like, Christine, from your perspective, both with the regulatory authorities and the DPAs and with law enforcement, that in Europe you may want to do that sooner rather than later.
Well, definitely with DPAs, absolutely. With law enforcement, probably as in the United States, we would advise our client to do a case-by-case analysis, depending on the country or countries involved, because you may have that element, of course, for an international company that may be indeed relevant and effective, notably if you anticipate that some element of the threat may be completely outside of the EU, for example. You may want to have access to law enforcement elsewhere. That's also something to be taken into account.
And Thore, I'm interested in your perspective on that, because I think Christine was mentioning the GDPR and some of the the angles around how we are conducting an investigation that would create issues under the privacy laws and data protection laws that exist in Europe. How do you see organizations striking that balance of trying to get after the truth and be able to protect their information resources, information assets, including personal data that may be in some ways in danger from a threat actor, while at the same time maintaining their compliance posture under the GDPR set of obligations?
Right. Yeah, I think generally the importance of data privacy laws, such as in particular the GDPR for internal investigations in Europe, can hardly be overestimated. Data protection obligations play a very important role and are one of the main reasons why investigating potential misconduct itself be a significant legal risk. I mean, the reasons for this are kind of obvious. On the one hand, internal investigations necessarily involve the collection and review of employee-related data. On the other hand, the scope of data privacy laws in Europe is very broad. They apply to any processing of data. This includes securing, collecting, reviewing data, as well as the creation of work products such as interview file notes and interim or final reports. And legal risks even increase if the investigative measures potentially cover private communication, which is highly protected in many EU member states. For example, in Germany, reviewing private communication may even constitute a criminal offense if data privacy requirements are not observed. Also, there are very strong limitations as regards workplace monitoring and surveillance, which need to be observed in order to avoid serious legal exposure. So, yeah, coming back to your questions, how can companies ensure that they comply with all of these obligations, but also conduct effective investigations? I think a very important aspect which addresses the data minimization and purpose limitation principles is setting the right scope of an investigation. So all investigative measures should have a specific purpose and be based on the available indications and allegations raised. So generally, the collection and processing of data should be limited to the scope necessary to achieve the legitimate purpose of the investigation. This in particular means that data reviews need to be limited to specific custodians. They also need to be limited in terms of subject matter or content, which is to be achieved by the use of specific search terms and also a limitation of the investigation period. So, it is clear that the scope of the investigation may change over time, and it might become necessary to add specific employees or search terms or to extend the investigation period. But all of these measures need to be carefully documented with a respective justification. So even several years after the investigation, the company needs to be able to demonstrate why specific measures were necessary based on the available information. So I believe overall the thorough documentation is key. The legal basis and justification for all investigative measures should be identified and documented. And the assessment should also consider internal data privacy notices and policies, for example, regarding the private use of corporate communication systems. And I believe another important aspect is transparency with respect to data subjects, so the employees and also the data protection officer. So as the GDPR stipulates very strict information requirements, it is necessary to either inform affected employees or to document why information duties are suspended.
So we're not saying here, Thore, that if Scott Loughlin is the subject of an investigation, that the company has to say, hey, Scott, by the way, we're investigating you for potential criminal activity and stealing our data. What we are saying, though, is that essentially companies need to go through a process to make sure that they are being limited and restrained in how they conduct an investigation, documenting their interests in doing so, and comparing that against essentially the rights and freedoms of those individuals as part of that investigation. Is that a fair summary?
Exactly. So the company should document why Scott Loughlin does not need to be informed for which reason.
Yeah, interesting. Christine, interested in your perspective on that, and maybe with the additional element is that the privacy-oriented laws are not the only ones that we would need to be considering as part of our overall investigative strategy. And, as you know, what is part of any cyber investigation, we are often trying to find as many insights into the particular issues that a company is experiencing. And so those insights may come from a variety of different sources. They could be from information that you're asking people about in interviews with your own internal team members. It could be information that you collect through forensics companies that you have engaged to assist you. It could be through log reviews, information that comes from your information technology department. It could be in the nature of communications and emails. All of the things are on the table, and we're always trying to make sure, say, okay, what is it that we're trying to investigate, and what is the best evidence that we can collect that would help us determine one way or the other as to how we're going to conduct the investigation. But Thore, I think, was just describing a set of privacy issues that would limit how you scope that investigation. And I think there are other statutes in Europe, blocking statutes, international data transfer issues that companies also need to be aware of as they conduct those investigations.
Yes, absolutely. You would have both statute which would apply even if you are not going to transfer any data outside of the country, for example. And you would have also statutes which would apply only if you want to extract data from one country to another. So, for example, in some European countries, you may have banking secrecy, which would prevent the communication of data, but even within one country. And I was going to say, and then, of course, it applies if you want to extract those data and communicate them outside of the country. But even within one country, you will not be able to have access to that kind of data. You may have protecting national defense secrets, for example. And then you would have also in laws that would prevent the transfer of information outside of one country. You have some European countries have adopted blocking statute. So why are we calling those laws blocking statutes? Because literally the purpose is to block the extraction, the sending of the information outside of one country. So the idea behind those blocking statutes is generally the same, i.e., protecting information which are considered to be of an economic, commercial, industrial, financial, or even technical nature. It was because most of those laws have been existing for probably 50 years now. For example, the French blocking statute have been adopted in 1968. The idea behind that was to prevent spying. But the way it is drafted can still apply now to the kind of investigation that we're talking about, because it prevents any person to disclose, whether in writing or also orally, document or information for the purpose of constituting evidence for a foreign, either judicial or administrative proceeding. So it's broad. This prohibition is under a criminal penalty. So obviously, if you engage in such activity, you may face a 6 months imprisonment or a criminal fine, which the choice of putting criminal penalty attached to breaching this prohibition is clearly a will from the French government to express that we are being serious about that. And there are exceptions. So basically, the exception is that you could obtain those evidence, but you need to follow, for example, the provision of the Hague Convention. So that would require that the French Ministry of Justice would have access to the question being asked and being able to review the information that may be disclosed in the context of a foreign judicial or administrative proceeding before those information actually being transferred. So this is clearly a big restriction to conducting an investigation when you have this element of extraneity of this international aspect.
And Christine, interested in your perspective on how to manage all of these differing requirements, because we started by talking about the need for having a small team, at least to start, to identify who is going to be trusted as part of this investigation, who has not yet been ruled out as a potential suspect. So as we start to collect and concentrate all of that information into that small team, there will inevitably be a need to gain access to records and information that may sit in other regions. So for example, if the investigation is being conducted out of the United States and we are concerned about a potential threat coming out of France, that there may well be the need to be able to have the US team be able to gain access to that. How do you see organizations managing against the restrictions that are included within these blocking statutes? Does that mean that they need to involve kind of a French stakeholder at the outset to be part of that investigative team? Or are there other strategies that you've seen organizations use to maintain their compliance with these obligations?
I completely concur with you. It's very important to have that team as restricted as possible at the beginning. And when the event would occur that the company would need access to information or document which would be in a country or in countries plural having those blocking statutes, usually there are ways to still conduct the investigation complying with the blocking statute with the proper guidance. So when that happens, absolutely, you would need to involve someone specialized from that country and to be sure that you would follow the national procedure to make sure that you're continuing to conduct the investigation compliant with the relevant laws. I would love to have a French lawyer for every investigation which are being conducted. That's not always possible from the outset, unless you know that from the beginning that the investigation necessarily is going to concern France. But clearly, what is important is to be agile enough, that the team is agile enough to be able to include one more member when it's relevant to include them. And also, it would apply for any EU member states. And as you know, there are many of them. So I think the requirement of having a restricted team is more important at the beginning than making sure that you would have the relevant person for each and every potential country. In any case, with Hogan Lovells, you know that you will have access to that network of people very easily. So it's going to be very easy to plug one more person to that global team.
And the global team, I think, is probably a necessity, it sounds like, and needs to be thought of as part of your overall process sooner rather than later. Thore, maybe I'm ask you for your perspective on kind of an important question here, because one of the challenges, as we keep repeating, is figuring out who is it that we can trust and who we can't. And I've had experiences leading investigations where it turns out that one of the members of our confidential privileged investigative team turned out to be somebody who was a bad actor. And as a result, kind of identifying and having those people be identified early is super important. And of course, when you're asking questions of employees about what, if any, misconduct they have engaged in, you may get a number of different reactions. Those could be ones where they admit everything that they've done, or it could be that you're getting a very defensive response, or it could be anywhere between, including people who are actively misleading you and trying to throw off the investigation. What is the duty of employees in Europe to cooperate and support an investigation that may be being conducted by their employer?
At least in Germany, I mean, it's debated, but there is a general duty of the employee to participate in investigations and to participate in interviews. However, there's not really a way that employers can sanction employees that don't participate. So that is usually the hurdle. I don't know how it is in France, but that's the way it is in Germany.
Yeah, that would be the same. There is a duty of fidelity of an employee towards their employers in France, for example. But this duty does not go as far as making it mandatory for an employee to actually participate in the investigation. And in any case, there is case law stating that an employee cannot be sanctioned or dismissed when testifying or in court, irrespective of the nature of the testimony. And from that case law, it is usually understood that an employee cannot be forced to testify. At least that's the situation currently as the French case law is right now. So it can evolve because it's case law, but that's the case right now.
Maybe just to add one aspect, while at least in many countries, there's no strict legal obligation, it is best practice to inform employees that they must not make statements that would mean any kind of self-incrimination. So, for example, in Germany, provisions of the German Federal Bar Association recommend avoiding any behavior of the interviewer that might pressure the interviewee to incriminate themselves. So that is also something to consider.
Interested in that point, because one of the aspects that often comes up is how individual employees should be counseled around engaging their own lawyers. And so in the US, we have this concept of upjohn and upjohn warnings, which means that if I were representing a client and we were interviewing you, we would have to warn you to say, hey, we represent the company. We don't represent you. Anything that you describe to us may be used as part of the company's operations, including, anything that you say that may incriminate you. Is there a similar concept under European laws and member states, or is that dynamic approached differently?
Yes, such upjohn warning is in fact also best practice in Germany and I think in most other EU countries. So while there's not necessarily a strict legal obligation, the interviewee should be informed that the lawyer attending the interview is the lawyer for the company and not the lawyer for the interviewee. And it is also best practice to inform employees that they have a right to attendance of own counsel. So in many cases, actually, companies allow such attendance and frequently also cover the costs of such counsel. And the same applies to the Works Council. So in many cases, companies allow employees to be attended by a representative of the Works Council and also inform the employee about this opportunity.
And maybe on a similar vein, one of the most important components that companies are sensitive to when they're conducting these investigations is attorney-client privilege and attorney work product protections. In other words, as organizations are looking to conduct a comprehensive and thorough investigation, one of the things that I think many of them would be fearful of is that they're creating records which ultimately could then be used against them, right? Which in concept, you'd say, okay, well, that could potentially create a disincentive to conduct the investigation to begin with. And as a result, making sure that we are sensitive to putting in the right types of protections for attorney-client privilege is super important so that we don't end up doing more damage than trying to make sure that the company has the right type of legal advice to help manage their legal related obligations. But I think it's also the case, and interested in both of your perspectives on this, is that privilege is not a consistent mechanism, or at least it's not interpreted the same way in the United States as it is in member states within Europe. Interested in your perspective, not only on those differences, but how companies can start to appreciate those differences in connection with an insider threat investigation.
Right. So you're absolutely correct. The privilege protection is or can be very limited in some EU countries, and it can differ significantly from the protection under US principles such as the attorney-client privilege and the work product doctrine. At the same time, the question of privilege protection can heavily impact the way internal fact-finding measures should be conducted. So I believe that it's good to briefly talk about it. So for example, in Germany, and the same is true in some other EU countries, an extensive attorney-client privilege only exists with respect to communication and work products concerning criminal defense. This does not mean that other attorney-client relationships are not protected at all in Germany. For example, lawyers have a general professional obligation of confidentiality, of course, and a corresponding right to refuse testimony in official proceedings. However, a strong protection only exists with respect to criminal defense, at least in Germany. In particular, even documents in the possession of lawyers are only fully protected from seizure if they were prepared for the purpose of criminal defense. This was actually clarified some years ago by the German Constitutional Court in its Jones Day decision. So what happened in this case was that prosecutors raided the Jones Day office in Munich. They seized documents relating to the internal investigation that Jones Day was conducting for VW in connection with the diesel matter. And I believe this included interview file notes, but also interim reports of this investigation. So, and when I talk to US lawyers about this, they're usually kind of shocked because I believe it's hard to imagine that the same could happen in the United States. So, I mean, this case was special in some ways. For example, Jones Day was instructed by VW, whereas the proceeding of the prosecutor concerned Audi, but nevertheless, it shows how limited the scope of privilege protection can be and how important it is to take measures to increase the protection. So while the scope of protection differs significantly within the EU, I believe there are some general standards and recommendations. So the first general recommendation, at least in sensitive cases, is usually the involvement of outside counsel, as in-house counsel is usually not sufficient for privilege protection in many EU countries. And I know I just talked about the Jones Day case, so even the engagement of outside counsel does not guarantee absolute protection, but it does give companies the strongest protection possible. For this reason, too, sensitive documents should only be available in counsel's offices or on counsel servers. It is usually advisable to work with data rooms with limited access and, depending on the specific document, potentially view only permissions for the client. Another recommendation, which is likely applicable around the globe, is that other service providers that support with the investigation, so for example, technical or forensic experts, should be instructed by outside counsel and not the company. And then in some countries, and in particular in Germany, it can be advisable to link the engagement of outside counsel to potential authority investigations or proceedings, as this can help to argue that communication and work products concern criminal defense, or at least the preparation of criminal defense. So it could be indicated in the engagement letter that the facts of the case could lead to authority investigations, and that the counsel is also instructed to defend the company in such proceedings. And then another obvious recommendation is to label communication and documents that are privileged, or for which at least there are arguments for privilege protections, to label them as such. While the labeling itself does not lead to privilege protection, it certainly raises awareness, and in case of dawn raids, makes it much easier to separate and seal documents to avoid an instant inspection by authorities. So I believe these are a couple of recommendations that increase privilege protection and that are rather applicable in all EU countries too.
Yeah, I mean, dawn raids on law firms, I think, would certainly scare a lot of people, at least here in the United States, and probably it scares folks in the EU too. I mean, Christine, interested in your perspective on privilege in France, including how much of the types of things that Thore was just talking about would differ between member states, or are those consistent principles that cut across multiple EU jurisdictions?
It's clearly an area where you have a lot of national element. So unfortunately, we cannot give you an EU-wide answer to that question. In France, for example, it is clear that in-house counsel do not beneficiate from any kind of privilege. And I know that's different from some other countries of the European Union. I also know that the privilege from which the communication of outside counsel with their client is, for example, broader than the one that Thore was explaining from a German perspective. So it's clearly very national, and even for countries which are based on a civil code system, for example, as Germany and as France are, there are still big differences. And obviously that's very tricky, because that's kind of the art of the issue, how much control that you can keep on the information that you are going to collect is absolutely crucial to our client. So that's absolutely a space, an area of law where you would need to consult with lawyers in different countries. And of course, we can do that at Hogan Lovells because we are present in so many countries, or we do have relevant and good law firms with whom we are working in European countries where we do not have an office. But that's absolutely crucial to be absolutely sure of the existing legal regime, but also of the case law, which in this area of privilege protection have changed a lot. You can have a lot of specific decision which can make the application of that privilege protection change from one year to another. So you really need to be on your toes on those topics and to be sure that you have the latest relevant information to conduct your investigation correctly.
Yeah, and maybe it goes back to that point, Christine, that you made when we were talking about the blocking statutes and how those can impose jurisdictional unique requirements in France and in other EU member states that would require the involvement of subject matter experts within those countries sooner rather than later. It sounds like on privilege, we're also in that same position, whereby there are similarities in the way that member states approach privileges, but there are also big differences. And so, Thore, I'm guessing that some of the practical advice that you shared a moment ago about how to address it may differ if we are doing an investigation in Germany versus in France versus in Italy and kind of any of the other member states where we would want to have, where we have people on the ground and need to be included with as part of the investigative team.
Yeah,
True.
and I just wanted to double down on the point Christine was making. It is very important to have this global perspective. So you need to be aware that the requirements for and the scope of privilege protection can vary significantly. And when you conduct fact-finding measures in one jurisdiction, you need to consider potential impacts on privilege protections, not only for this jurisdiction, but also for other countries. This is in particular relevant as in many cases in the early stages of an investigation, you simply don't know whether there are implications for other countries. So, for example, a US company or law firm conducting an investigation in Germany needs to be aware of the limited scope of privilege and protection in Germany. But on the other hand, when communicating and potentially cooperating with German authorities or other stakeholders, one should also be aware of potential consequences for US privilege protections. So measures should be taken that reduce the risk of a waiver of privilege. Generally, documents should only hand it over to authorities based on formal request by these authorities. And there are other measures to be taken to reduce risk that privilege is actually waived.
But the 5 elements that Thore was mentioning to protect privilege, we came up with those 5 elements being limited access in any case. I mean, a restricted team at the beginning, making sure to label your email and communication with privileged and confidential information, not a complete shield against communication to authority, but still a good label to have, making sure that to instruct the service provider through an outside counsel, making sure that you have at least one EU outside counsel in the team, because in case you have an EU member state involved, that would be a start. And then you may want to involve people from the specific countries, but at least having one EU lawyer would help from the beginning, and also making sure that the engagement of the outside counsel is precise and clear. Those are elements which are going to be helpful in every member state of the European Union. And then you can always add layers, but those are very good foundations that are helpful everywhere.
And I would add, Christine, maybe as a subtext of what you were describing, is that all of those things, we need to get them right from the outset. In other words, it's really hard to conduct an investigation and then start to do those things, as opposed to making sure that our clients who are well advised in this space know to start doing and putting in together those safeguards and those protections and those structures at the beginning of the investigation, as opposed to trying to do it at the end.
Absolutely. The earlier, the better.
And it's actually something we do, like in the first client briefings, we explain the background of privilege protection in Germany or in other relevant jurisdictions, and we align on the appropriate forms of communication, information and documents provided to the client. So that is always something we do in the first meetings with the clients.
That's super helpful. I really appreciate both of your insights. I feel very lucky to have you as part of our insider threat team here at Hogan. I can't tell you how many times that you have come to help clients in their circumstances where things are really difficult and they need those trusted counselors to help them navigate some of those pitfalls, helping them kind of protect themselves in connection with these really difficult insights. With that, Christine, Thore, great to have you on the podcast. Thanks so much for joining us. So with that, I'm Scott Loughlin. This is the Data Chronicles, and those are your data points.